welcome to the part 2 of our series on Justice Nageswara Rao. As we have said, what is judiciary's loss will be the arbitration world's gain. In part 1, we delved on his tenure, and Parag Tripathi, senior advocate, just had started speaking about his judgments. In part 2, we'll continue that journey. A couple of anecdotes on him, a couple of comments on his judgments, and I'll reintroduce the panel to you. We are with our senior advocate Parag Tripathi, advocate Rohan Shah, Mohit Saraf, managing partner, Saraf and Partners, and Ruby Singh Ahuja, senior partner, Karanjawala and Company. Welcome all of you. Senior advocate Parag Tripathi, for you to complete the comment that you started on Justice Nageswara.
No, so therefore I said that his legacy will remain there. His indelible stamp will remain there, and he was, of course, also extremely hardworking judge, and he has left a very important mark in his judgments, as I said, in the areas of personal liberty, commercial law, and several other fields where he has forayed in writing his judgments.
Okay. Thank you for that comment. I'll go to Advocate Rohan Shah for his comment on the judgments of Justice Nageswara.
I think, like one might expect, given his stature and standing, we've seen during his tenure, I think, a very wide width of judgments on several issues. And of course, Mr. Tripathi mentioned a few of the critical ones. But, let me maybe isolate a few. And thematically, I think his focus on the justice delivery system, not just, through the courts and not just through the civil system, but this Madras Bar Association judgment of his, which is the second round of Madras Bar, I think came in a circumstance when the credibility of tribunals and their relevance was under very, very serious debate. And as the Honorable Chief Justice, I think, has remarked a few days ago in the context of Justice Rao, that his judgment in Madras Bar, sanctifies in some manner and supports the tribunals as expert bodies who have a role and a relevance in the justice delivery system. And he then squarely takes on several of the criticisms or, faults in the architecture of the system. And, within that, the passages that he has on separation of powers, independence of the judiciary, I think will stand the test of time because, they are so wedded to the basic principle and tenets, and at the same time are, so simply expressed. He also sort of dealt with certain issues in the tribunal system, which came in probably inadvertently, like the minimum age at which even a lawyer of good standing could be appointed to a tribunal. And he very seriously questioned that, to say that if ability and integrity were inherent, then from that perspective, it was no point having a sort of minimum age, because you were denying a person desirous from pursuing a role as a judge. But more importantly, you were denying the judicial system the ability and capability of that individual. So I think some of these and judgments really go a very, very long way in that direction. Another judgment that I found remarkable was his judgment in the context of the whole criminal trials and related guidelines. And, several of the concepts, but particularly his reading of section 207 and 208 of the CRPC, where he says that even at a pre-trial stage, all the material available in investigation must be made available to the accused, including what is not relied on, and therefore could be exculpatory for the purposes of the accused. I think, again, in the justice delivery system, this had a huge impact in terms of the general criticisms of how criminal trials are conducted. And then, more recently, I think, on the Maratha reservation issue, sitting in a bench of 5 judges, one, the factor that, we were really talking of a threshold of 50% reservation to go up, and the impact that would have, and the view taken and very strongly taken and stated that there were no exceptional circumstances to deviate from the test in Indira Sawhney. And from that perspective, that, we shouldn't open up more doors, which were based on either accidents of birth or religious persuasion. I think in there also, there is this really interesting set of passages on cooperative federalism, state versus center, how they interplay within the constitutional framework. And more recently, that has also been picked up in the context of the GST Council by Justice Chandrachud in this Mohit Minerals. But to me, the factor of how prolific a judge he was in terms of the number of judgments that Justice Rao delivered, I think that is only in a manner matched by the erudition and knowledge that he brought to the subject. And it was on a wide variety of topics and issues. So I think he has left us a very substantial legacy, and his judgments will be oft-quoted and re-quoted because I think they quite simply lay down the guiding principles, both from a constitutional perspective, and in the context of other laws. So I think some of these issues and judgments have stood out for me.
Thank you. Thank you for sharing that view with us. I'll go to Ruby Singh Ahuja, Senior Partner, Karanjawala and Company, for her comments on the judgments and reflections on the judgments given by Justice Nageswara Rao.
Thanks, Tarun. So, we normally, all of us lawyers form the impression about and have view about a particular judge because of his judgments, which we call, little long judgments or not orders. It's, you read whether it's Justice Rao's judgment on tribunals, on Negotiable Instruments Act, speedy trial, and so on. And we know that he has been, remarkable when it comes to even commercial issues. He has sat with Justice Bhatt on the issue of insolvency against the personal guarantors. But I also feel, sometimes you also get a view about the judge when you read his orders. And I'll tell you where I'm coming from. I was just going through reading some stuff about his orders and all. And I realized that sometimes the orders of an honorable judge, what he caters and brings out to fit into the requirement of society, also tells you that his heart is at the right place. Whether you talk about his, I was very surprised that about his 3 orders, and I'll tell you which one. He gave, Telangana had cancelled 19 lakh ration cards. He stood up and he's without verification. And he came heavily and he said, it's not a luxury litigation. People depend upon this for their food. You cannot cancel it. He issued notice for gig workers. Thirdly, when it came to Jahangirpuri demolition, he gave status quo. So, I feel that sometimes in a country like India, where, the judges will have to do a little bit more than what is required under the 4 corners of law or a statute. Because we have some marginalized strata of society which needs protection and hand-holding. And there, I think a judge who's sitting in the apex court has to rise and help that strata of society, which I thought that these have been very fine orders to protect. And I'll tell you, sometimes the law may not be completely in the favor of a case, though I'll digress here. I remember I was with him in Hyderabad doing a case, and I was showing him all section, subsection, fully charged that, my case is so good, this all. He said, you're right on law. Your facts are very bad. You will not get the order. So sometimes, our facts come into play. So where the judges, as a judge, because he had that experience, he knew that sometimes very discrete fact, very difficult facts are there. The law may not be helping, but then the Article 142 can help. If you see even his, one of the panelists, I think Rohan mentioned his judgment that it's a duty of the son to protect his, look after his parents. I was reading there another judgment when nobody knows, when you read, then you realize that the man is looking after to protect various strata of society, not only commercial, that he has written a judgment sitting along with Justice Shah, where he said that if a man indulges in sexual activity with a woman on a false pretext of marriage, you can bring a charge of rape. Now, whether it fits squarely in law or not, but he has looked into the society, he has looked into the requirements of the country, and that is why such orders are passed. So I think, this is very important, and this makes him different from the others. So, but as I said, that now we'll see, he has a very interesting domain to this arbitration, I'm sure, and that will be a good thing for us because he has his experience now, both sitting as a member of the bar and member of the bench.
Okay. Thanks so much, Ruby, for again bringing in anecdotes which you bring in for the show. Thank you so very much for that. I'll go to Mohit Saraf, managing partner, Saraf and Partners, for his comment on the judgments made by Justice Nageswara Rao and his observations also.
I think three of my panelists have covered a lot of judgment. I think what has been missed out is the constitutional part. So maybe let me give a hit at that. I think we did mention that he was basically always looking at federalism and protection of institutions in India. I said particularly on the ordinance issue, he was part of a constitutional bench. And if you look at read the judgment and you look at his personal observation, that he was very clear that ordinance as a constitutional mechanism is for 6 months. And after that, it lapses. And for him to go to a point to say that any promulgation of ordinance is a fraud on the Constitution, which is and also it derogates the entire legislative framework. These are very strong words. He was part of that constitutional bench, and I think a lot of his observations, Justice Lokul was also there. So it was a very, very strong bench where he was part of it. And I would say not that it has changed behavior both at the center and the state, but I would say at least he set a very strong judgment, which I think same thing is actually on the People's Representation Act. If you see that clearly, because we all have seen elections fought on caste, creed, religion, language, and to say that any appeal by a candidate based on his own religion, caste, religion, creed, or whether the voters, even if it is appealing to the voter, and he interpreted his to include voters, so that if either you're using your own language or your own religion or voters' religion, both are corrupt practices. So these are very, very strong thing. And I think in my view, he's done. And even on reservation, if you look at, I think Mohan mentioned about reservation, he has actually consistently looked at reservation as a positive discriminatory policy and has supported it. But what he's not supported is political usage of this reservation. He says, please, if you want to reserve more, please show me that that these are weaker sections. And that is the reason why Marathas were rejected, because they did not qualify as weaker section. And the second bit he said is that also show me based on data that they are not properly represented. So all the times you've seen reservations done in public offices based on sound principles or research. So I would say to that extent, because a lot of times we see in India that when we get closer to the elections, this is done without any basis. Wherever there's a huge amount of vote bank, you just do it. So I would say to tell that anything which is without a basis is bad in law, and therefore people have to really do it what helps, not do it what gets vote. So I would say is that way a very high level and also detailing. It's a very, he says, he did not say everything is bad. He says, okay, if you can show me the data and it's based on intelligent differential, then it makes sense. Otherwise, it does not. So I would say on all issues, he's left a very huge mark. Particularly, I would say I respect him that in the time when everybody in this country thought that anybody who's not vaccinated should not be permitted to go to any public place, he said right of vaccination is a right of privacy. And equally, he put a very strong requirement on the government to make sure that the ill effects, because that time nobody knew. A lot of people did not even go to the vaccination center for first few weeks because they wanted to see the impact on others who got it. And he said, no, now you better put the adverse effect, the reports in public domain. So I would say he's done a long way, and I see what they did it in Australia to the Australian Open player. So I would say people like him leave a very strong mark. But I think, in my view, being a commercial lawyer, I feel a person like him, the detailing he gets in, I would say will be really welcome at the arbitration, because that is what is not working to the extent it should work, because enforceability of contract, even in arbitration, if take that long, then it really defeats the purpose and it makes the cost of doing business very expensive in India. And I would think that for him to move to the arbitration practice, particularly supporting the Hyderabad center, which is at nascent stage, will go a long way and will help the cause.
I go to Senior Advocate Parag Tripathi. As Mr. Mohit Saraf shared with us about everybody looking forward to his tenure at the Hyderabad International Arbitration Center. Senior Advocate Parag Tripathi, do you have a wish list? Some inputs or recommendations and a wish list, because Justice Ramana had this plan to put Hyderabad on the international arbitration map with this center. But of course, since you yourself have a good arbitration practice along with your practice at the Supreme Court, is there any wish list that you have that you would like to share with Justice Nageswara?
I think the wish list is quite clear. For successful arbitration, for a successful ecosphere in arbitration, you need basically three things.
Okay.
You need good, independent, impartial arbitrators. And in India, unfortunately, though it is a contested point, but unfortunately, most of our good arbitrators feel some kind of an umbilical cord link with the party which nominates them. It's like a legal fiction. You have to understand that, yes, Mr. Saraf has nominated me, but once I am nominated and I am sitting as an arbitrator, that nexus is over. It has no relevance. So that is one part of it. Secondly, it has to be quick and comparatively inexpensive. That doesn't mean that arbitrators get ridiculous remuneration. Then you won't get good people. It's like our academia today. There's bad remuneration, you don't get the best people. So your remuneration has to be taking into account what circumstances are, not unduly low, because then you won't catch the cream. And the third is something, of course, where the arbitration center by itself can't be of help. But the third is that the execution has to be swift, and best should never be the enemy of good. If it's a possible view, well, then that's the end of the matter. So these are the three areas. Two of them, I think, Justice Nageswara Rao's presence can go a long way. Choose the right kind of panel of arbitrators who have the right approach, that once I become an arbitrator, I'm like a judge. There's no difference. There's no question of private communication, no question of carry forward of views or support. I am as independent and neutral as any of the other two on my tribunal. And of course, the second, that remuneration has to be good and processes have to be quick.
Thank you for that input, sharing those inputs with us. I go to Advocate Rohan Shah for his inputs on Justice Nageswara Rao's arbitration, in a sense, which can be truly called the next phase of his career, because served on the bench now for 6-7 years. Now, this is another two and a half decade career. So it's not it's a big contribution that he's going to make in the arbitration world.
So, I think many of the qualities which marked out Justice Rao as an outstanding judge will obviously continue to serve him extremely well in the next phase of his career, depending on how much he wants to do in arbitrations. But as we know, in our situation, there's a almost unequal and unusual burden on the Supreme Court, because almost every stakeholder looks to the Supreme Court as the forum where they will get resolution. And this goes from every part of our group of citizens to government to institutions, etc. Now, when you are in that Supreme Court and you come up before a judge, what you are hoping for as a litigant is that, of course, you will have someone who will hear you fully, who will bring their wisdom to play, whose integrity is unimpeachable, and who follows consistent, predictable approaches to key issues. And I think that is where Justice Rao truly stood out amongst an array of some other outstanding judges. The issue really is that it is these qualities that the commercial world also needs in arbitration. The ability to trust someone, to trust their knowledge, to trust their ability to fairly and quickly dispose of cases is vital for the arbitration system to really thrive and continue to be relevant. And I think the same skill sets that he brought to being such a respected judge of the Supreme Court will serve him extremely well in the context of the new role that he plays. And I think somebody like him really has the personality and impact that, the sort of slight, but some of the clouds over the whole arbitration process in terms of time and integrity and other things, hopefully a personality like him can dispel many of those and inspire many others.
Thank you for that input. I'll go to Ruby Ahuja, senior partner, Karan Javala and Company, for her comments on the arbitration journey of Justice Nageswara Rao and some recommendation if she has it.
I have only one request to make him. Please bring the same discipline which you have in your court to the arbitration world. Firm, bold, polite. And I think there has been some element of still casualness in arbitration world, unfortunately, which we really, really need to give away. Because if we don't, this will not affect only your court, your arbitration, execution, enforcement, all that we all know litigators are problem. It gives a bad impression outside. Your ease of doing business and all takes a toss if that arbitration, you don't do it in a more strict manner, whether it is an arbitration or the commercial jurisdiction of some high court. Having said that, one request I have for him is, I think one minor step which every arbitrator should take is no arbitrations after 5 o'clock. It is not a part-time job. It is not. No arbitrations on Sundays. Arbitrations should be done as court proceedings. What is it? It's an alternate dispute resolution mechanism. It should be done like that. We need the same discipline, and I think things will work, because no amount of amendments will help us if this attitude. That's all my request to him will be.
Thank you for sharing that input with us. I'll go to Mohit Saraf, Managing Partner, Saraf and Partners, for his message to Justice Nageswara Rao and the maybe 3 decade journey that he will now possibly take in the arbitration world. And of course, will leave an impact with the kind of position that he will take up at the Hyderabad International Arbitration Center.
I think we all unanimously agreed that he's added a lot of depth in his judgment, and he's absolutely a top legal luminary. And therefore, I think I don't want to focus on that. To get an arbitration center successful, now he has to wear a commercial hat. That's what it is. I think judicial hat work is over. Now he has to understand, I think you have to relate to how SIAC was commercialized. I remember the person who became the finance minister of Singapore used to personally visit law firms in India and ask, what is the problem? Why are you not coming here? Why are you going to London? Why is ICC? This is much cheaper, much quicker, much faster. We will bring this change, that change. I think in my view, and that just does not stop with Justice Rao at the arbitration center. This probably is required every sitting judge as well. And really, at the end of the day, what comes to them is commercial dispute. It doesn't really, 80%, 90% is all commercial dispute. And if you cannot resolve it commercially without understanding and appreciating what the client wants, what is the dispute all about, what do you want? And because one party will always ask for time because it is in his interest to delay the proceeding. And I would say, because I have seen whatever he has done, be an actor, be a Ranji player, whatever he has done, he's done to perfection. And therefore, I feel that now he has to wear a different hat, a more commercial hat and a competitive hat, that he has to bring it, that why should people go to Singapore? Why can't they do it in India? And that is what he can do it. And if he can do, that would be the biggest service for the government, for the country, that basically our issues, and also it will bring a lot of discipline, I would say, in our judicial behavior. I would say a lot of time, because of interventions at multiple levels, a lot of clients have started saying that there's no point doing arbitration in India, because you're basically fighting at arbitration and then you're fighting at multiple levels at High Court and Supreme Court. And therefore, it is better to do Supreme Court and High Court, and therefore just let the courts decide. So I would say, and that is not in the interest. And therefore, it is very, very important. And he has seen it from the bench. He should now look at it from warring parties and make this thing an impactful change. Things have improved, but I think there's a long way to go. Enforceability of contract is very, very poor. We can never get to $5 and $10 trillion with this level of enforceability. Because if everything is delayed, somebody makes money with the delay. And somebody actually has an ability. And lawyers often don't understand that issue. And therefore, you need a very strong person at the arbitration center, and particularly because he would have access to everybody in the bench at the High Court and the Supreme Court. I would say that can change, and that can help change the judicial behavior. And like you've seen.
Thank you so very much, all of you, for taking part in this two-part series on Justice Nageswara Rao, and also wishing him well on his journey in the arbitration world. We sincerely look forward to it. He will be a part of this arbitration world with us for the next 2.5, 3 decades in the least. And many of us will get to talk to him. Many of you will get to work with him, appoint him, or I don't know in what all ways can you be associated. But I would like to thank Ruby Singh Ahuja, Senior Partner, Karanjawala and Company, Advocate Rohan Shah, Mohit Saraf, Managing Partner, Saraf and Partner, Senior Advocate Parag Tripathi, for making time and joining on this two-part series. And thank you, viewers, for tuning in. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.